Next case is Towey versus Bank of New York, Melton.
May it please the Court. I'm Mark Stopa, counsel for the appellants. I would request 5 minutes for rebuttal.
Sure.
Your Honors, this is an appeal of an adverse summary judgment of foreclosure. There were numerous issues of fact that should have precluded summary judgment. This Court should reverse. The first issue that I think is just very clear is that there was no summary judgment evidence before the Court at all. The affidavit upon which the plaintiff relied was verified to be, the facts therein were verified to be true and correct to the best of the affiant's knowledge and belief. There is a long line of cases which make clear that that type of attestation is insufficient for summary judgment purposes as a matter of law.
Are you talking about the Pittman affidavit?
Correct, Judge.
But doesn't he go on to say, he does say it's based on knowledge and belief, but then he goes on to say that he could competently testify to the facts contained herein. He goes through why he knows what he knows, and then he says he has personal knowledge of the facts stated herein. So doesn't that bolster his initial comment or his initial assertion that it was based on knowledge and belief?
I don't think so, because a legal conclusion that you're able to testify about something doesn't support the analysis. And at minimum, even if you were to accept what you're trying to say, there's an internal inconsistency in the affidavit as to whether he actually has personal knowledge or not. When you include a statement indicating that the facts are true to the best of your knowledge and belief, the law is very clear that that does not give rise to summary judgment evidence as a matter of law. And there is no case that supports that proposition. There's no case that supports the proposition that, well, I said this was true to the best of my knowledge and belief, but I bolstered it by other statements or bolstered it by something like that. There's just no case that my opponent can cite to or that exists that supports that. Instead, I think the cases are all very clear that when you have that type of equivocation, that the law does not treat that as summary judgment evidence. This is summary judgment in lieu of a trial. It's a very high standard. There has to be conclusive proof leaving no doubt at all. And that's why this Court ruled in Ballinger in 2010 that a knowledge and belief attestation is insufficient as a matter of law. And several other DCAs have followed that decision in the years since. Cologne, Lindgren, Toyos, out of the 4th and 5th districts respectively, are all in the foreclosure context and all rule that where the information is an attestation or verification is set forth on knowledge and belief, that's not sufficient for summary judgment purposes as a matter of law. I'd encourage your honors to ask my opponent for any case or authority that supports their contrary position. They won't be able to provide one. Instead, what they try to do is they try to say, well, the problem here, they try to distinguish the cases that I've cited by saying, well, the problem in those cases was that the attestation or the verification was done in a pleading, in a complaint, as opposed to in the affidavits. But that's a distinction without a difference, because in Botcher, this Court in 2004 ruled that a verified complaint, if verified correctly, consistent with the summary judgment rule, can constitute summary judgment evidence sufficient for a summary judgment. I don't dispute that proposition of law. If a complaint is verified under oath, under the penalties of perjury, in an unequivocal way, then it can constitute summary judgment evidence. The problem here is that their affidavit that they rely upon was not done in an unequivocal way. There has to be an unequivocal attestation. And it has to be a black and white issue, Your Honor, because otherwise, we can't, at the summary judgment stage, there can't be any question, okay? And I think the mere fact that you ask the question of, well, does this bolster that, shows that it's not summary judgment evidence, because when you have that equivocation in the affidavit, we can't tell if he's testifying on personal knowledge or based on knowledge and belief. And I can tell you he's not testifying based on personal knowledge, because almost all of the affidavit says, the statements in it are, say, based on the loan records, or the loan records reflect. So no witnesses in foreclosure cases have percipient knowledge, the term that I know Your Honor likes. They don't have percipient knowledge. They are testifying based on documents, right? So in a trial context, those documents have to be admitted into evidence. In the summary judgment context, those documents have to be attached to the affidavit, or the documents upon which the affiance summary judgment statements are predicated are not attached to the affidavit. That's not summary judgment evidence as a matter of law. This court so ruled in Zoda and CSX in 1992 and 1995, respectively. In those decisions, there were statements in an affidavit which were based on the content of documents. Those documents were not attached to the affidavit. Both times this court reversed, concluding that there was no summary judgment evidence. So I think you can tell not only from the equivocal statement of knowledge and belief, but you can tell from the context of the affidavit and the way that it's set up, and that all of the statements are predicated upon, well, this document says this and this document says that. And that's not only not personal knowledge, it doesn't give rise to summary judgment evidence as a matter of law. Now, when those documents aren't attached. Now that parlays nicely into the next issue that I want to talk about, is that there was no conclusive proof as required for summary judgment purposes that the paragraph 22 letter was actually sent. This court's decision in Edmonds and Allen are both very clear in indicating that the mere existence of the letter does not prove that the letter was mailed. You have to have separate proof that the letter was mailed, and that can come in a couple different forms. It can come through some sort of documentary evidence, such as a mailing log, or it can come through routine business practice testimony. In this affidavit, there was no routine business practice testimony at all, relegating the affiant to reliance upon documentary evidence, but there was no documentary evidence attached to the affidavit showing that the letter was actually mailed. There was no mailing log, notes log, return receipt, green card, anything like that that would show that the letter was actually mailed. Instead, the affiant said, well, the letter was mailed based on the loan records, or the loan records show the letter was mailed. Well, if those loan records aren't actually attached, then that statement is inadmissible hearsay, and inadmissible hearsay cannot give rise to summary judgment under the plain language of the summary judgment rule, because the summary judgment rule provides that the court can consider affidavits, admissions, etc., as would be admissible in evidence. So we know from Edmonds and Allen that testimony as to the mailing of a letter without routine business practice evidence and without documents is not admissible. And we know in the summary judgment context to say that a letter was mailed, the statements have to be admissible as they would be in trial, and they're not without the actual document showing that the letter was actually mailed. And so they needed to attach a mailing log or something like that, and that's just not attached. So there were issues of fact with respect to paragraph 22, and that the plaintiff...
As to that, the discrete argument, I want to make sure I understand it correctly. You're not arguing that it would be impossible for an affiant to say, I mailed a letter on April 30th, 2017. What you're saying, if I understand it correctly, is that it would be improper for an affiant to say, based upon records that aren't attached to the affidavit, it appears that a letter was mailed, passive voice, on April 30th, 2017.
Yes.
Am I getting that?
Yes, and that's a great, I'm glad you asked that, and I should clarify, and your question creates a good point of clarification. It is theoretically possible for an affiant or a witness at trial to say, I mailed the letter. I don't think I have ever had that happen in the thousands of foreclosure cases I've ever had, but that is possible to say I mailed the letter, in which event you wouldn't have to have the mailing log. I agree with that. This witness, though, did not say that he personally, or she, I don't remember who it was, mailed the letter, okay? So without the statement that she mailed the letter, you have to have, if you're relying on business records to show the mailing of the letter, you have to have those letters attached. So I agree with the distinction that Your Honor was making. It is possible for someone to say, I mailed the letter, but where you don't say, I personally mailed the letter, and you're relying on the passive voice or the documents show it was mailed, those have to be attached. And there's no cases...
I know what you're arguing from Rule 1.510, which is you have to attach the documents that you're going to rely on at the motion for summary judgment. And this involves business records exception to hearsay, which says if you're going to rely on a certification that complies with, Section 90.902, you have to give notice of that so the other side can have an opportunity to come look. And it's a reasonable, it doesn't say so many days. So isn't the document they're relying on here, the affidavit, if it complies with 90.902, which is a certification of the existence of these business records and that they were made contemporaneously or near the time by people with knowledge, which this affidavit says. And isn't that the document that they're relying on that was indeed attached to the motion for summary judgment?
Well, no, because there was no document attached to the motion for summary judgment showing the mailing.
There was an affidavit that says the loan records, which he says are business records, and he makes a certification that seems to comply with Section 90.902. The loan records reflect that they sent a demand letter, notice of a default by first-class mail.
Okay,
So that's what he says the records reflect, and they have submitted this affidavit, and under 90.803, you have a reasonable opportunity then to say, look, I want to inspect these records to see what they say.
Okay, I think I understand what you're saying.
The hearsay exception seems to contemplate that you can rely on that certification as your evidence, as the exception to the hearsay rule.
Okay, but a couple things. One, they weren't traveling under the certification, and two, Rule 1.510E makes very clear if you are relying on records in a summary judgment affidavit that those records have to be attached. That's why this court in Zoda and CSX was very clear in those cases in saying those affiants both relied upon documents that were not attached to the affidavit in order to make their sworn statements, and this court both times said you can't do that without actually attaching the documents. Here's another way to think of this, is that could a summary judgment affidavit has to contain facts that would be admissible in evidence at trial. So at trial, could the witness show up and say, the loan records reflect that this letter was mailed? Could the witness say that without actually introducing the letter?
I'm just looking at the evidence code, and it says if you're going to rely on a certification rather than the documents themselves, you have to give notice ahead of time. That seems to contemplate that you can rely on that certification, which this affidavit seems to comply.
Well, they didn't rely on they weren't traveling under that statutory.
Well, I don't know. They submitted the affidavit, and they didn't submit the records themselves, and so it seems to me that they were.
Well, they never said that. They never argued that. They never briefed that. And the position that you're now espousing, there's no way to reconcile that with this court's decisions in Zoda and CSX.
Well, I'm not going to vouch for that, but how long ago was Zoda?
They were in the 90s, 92 and 95.
And when was this current version of the evidence code, 803, done? I think it's more recent than that, to tell you the truth.
Judge, there are a lot of cases that follow that are more recent too. Zoda and CSX are just two that I use all the time. But I don't think that you'll find any case that supports the proposition that you can have hearsay statements in an affidavit based on documents that are not attached because you're purporting to, now Your Honor saying purporting to travel under a statute in the evidence code that they didn't even say that they were traveling under and didn't even brief at any stage in the process. So I don't think that that's a basis to affirm here. I also think, getting past that initial point of how they didn't meet their initial burden of proving the letter, our affidavits created a factual issue about whether the letter was mailed because we have affidavits that clearly deny receipt of the letter. Now, there are 4 DCA decisions that I cite in the reply brief which make clear that when the issue is whether a notice is mailed and you have a sworn denial of receipt, the denial of receipt creates a factual dispute about whether the notice was actually mailed. Banton, Kyrie, Tuati, and Bowman 3 third DCA cases and 1 first DCA, all support that proposition, which I think is very clear when you consider the summary judgment standard and the definition of relevant evidence, okay? Because what is relevant evidence? Evidence tending to prove or disprove a material fact. Now, when you have someone who says, under oath, I didn't get that notice, I did not receive that, that tends to prove that the notice was not actually mailed. That's not conclusive proof, and this court even held that in Ostrander. It's not conclusive proof such that proof of non-receipt would give rise to a defense summary judgment, but it is certainly relevant evidence because under the very low bar of relevance, non-receipt tends to prove that it was not sent. Now, at the summary judgment stage, all inferences have to be resolved in favor of the non-moving party. So when we have affidavits that say, we did not receive this notice, that creates a factual dispute as to whether the notice was actually mailed.
Going to the factual disputes on affirmative defenses, can you flesh out your response? One of the affirmative defenses that your clients raise is the unclean hands defense, based upon what they say was a course of negotiations that was going on about, I guess, a loan modification. Your opposing counsel cites some cases that one of which arises in commercial real estate joint venture context, but stands for the proposition